The next case on our docket is State versus Perry. Each part will have 15 minutes to present the argument. The appellant may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
5 minutes for
All right. I'll be keeping the time up here, so I'll try to let you know when you get about a minute left in your time.
Thank you.
So we'll give you some more. The arguments are being recorded. When you present your argument, please introduce yourself, keep behind the podium, keep your voice up so we can hear you. You should not use the name of any children, minors, and victims in this case. Please make sure you refer to them by initials or some of the term like the child, if you will. We've read your briefs and are ready to proceed whenever you are.
Thank you. Jack Corrigan on behalf of Appellant Shane Perry. We are a common law country, and in a common law country, we prohibit other acts or similar conduct to prove that the defendant acted correspondingly on the day in question. The state makes a point in its brief, parses things, and they're accurate as to that parsing. Rape shield and the common law apply to counts 1 and 2. Rape shield is not in count 3, but certainly the common law applies to count 3. So whether we're discussing rape shield or the common law, the court made a mistake, made an error in law in introducing the 2 exhibits. Exhibit F was a browser history of searches that the appellant had made on the cell phone. I know at trial they kind of had this sub-argument, well, it could have been somebody else's cell phone, but I didn't argue that because it looked overall that argument falls flat. In any event, Exhibit F was 62 pages of web history. The good news is that the web history involves searches within the time frame of the indictment, October the 8th of 20 to October the 18th of 20. The bad news is that they contained information that was simply prejudicial and irrelevant to counts 1, 2, and 3. The fact that you web searched a video about skinny teenagers, the fact that you web searched a video about daddy bangs daughter when mommy's away, the fact that you web search videos showing older people, old and young, in other words, inappropriate age conduct, can only inflame the jury. The state says it's relevant. Well, and he says any evidence that hurts the defendant is prejudicial. The issue, I would put it, it's other acts, the evidence is always marginally relevant. However, its prejudice is.
Well, here part of the one element at least was dissemination of pornography to a minor. You had to show some pornography that the person had to disseminate. So it seemed to me at least it would show here is a list of things that were on her phone that were searches for pornography, so he may in fact have had pornography to show somebody. So at least it's relevant as far as that purpose goes. Well, was there any request to somehow limit the description of the pornography on that particular exhibit? In other words, you've mentioned the names of some of these titles of these videos. Was there any attempt to try to limit that so that...
The objection was in total to Exhibit F.
Was there any limiting instruction by the court in any way about the exhibits that were admitted?
There was no limiting instructions. And again, because you have something on your phone, and whether you showed it to another person brings it to a different level. There was no proof that, I mean, the girl testified to seeing one video, which later becomes, I guess, admissible. That's Exhibit L, fellatio. So the fact that you're telling the jury that the guy's just, you're telling like a jury, the guy's a pervert. I mean, who touches little girls and exposes themselves, but a pervert? Take it away from the phone, take it to, 20, 30 years ago. If the guy's charged with a sex offense, you do a search warrant of his home and you find pornography, that doesn't make it admissible. The girl testified to having seen a video. Exhibit L, F in no way corroborated that testimony, at least, or, well, it did so, but only prejudicially. L, the one, was going to be a series of videos, but it was later pared down to one video. We don't know when that was shown. We just know that it was downloaded onto the phone, and it was consistent, but it was inconsistent. The shirt description was backwards. The blonde in the video was not, she testified that it looked to be a 10 to 15-year-old girl performing it. I went down to the clerks, it wasn't a 10 to 15-year-old, it was this heavily campus protester, hair-dyed blonde, crazy blonde. Wasn't 10 to 15, and she had the shirt mixed up.
Check the shirt, who was wearing the shirt mixed up. There was a green shirt, but I understand your testimony, the video showed the woman wearing it, not the man, or vice versa.
Right, I forget which way, but it was incorrect. But even assuming, so in our view, that should not, she didn't, hey, this is the video. She described the video, which is sufficient to go to the jury. He showed me this. That now becomes a jury question on whether there was dissemination. But she was never said, Exhibit L, yes, that's the video that I saw. We're just guessing. So she never identified that video. They had the opportunity to do that and did not. So
well, she described the video, and then one was played. The jury certainly could have decided from her description this was or wasn't the same video. And I presume that counsel had the ability to argue, look, here's why they're different. This person doesn't look 10 to 15. This person, different person wearing the shirt, blah, blah, blah. She could do that. Otherwise, what you're suggesting is we should have subjected a very young child to, again, watching this pornographic video and saying, hey, is this the one you saw before or not? That doesn't seem like a great solution to me.
Okay, but I think clearly Exhibit F, the browser history, was just, it was, I call it my brief.
I think the
carpet bombing, the guy's a pervert.
I think the state claims, I understood their brief, that in part they submitted all that because the defendant alleged that I don't watch any pornography at all. And this was kind of to show for credibility purposes, wait a minute, there's a bunch of pornography.
That is that's a good question and a main point of the state's brief, but it's the defendant, as the state puts in its brief, the defendant put this into issue by denying that he looks at porn on his cell phone. Detectives, and I'm not blaming them, they're not bound by the rules of evidence when they ask questions. The detective's question was an inadmissible other acts question. Do you watch pornography on your cell phone? Yes or no, that can't be admitted. Think of a domestic violence. You got a guy, you're interrogating him, he's been convicted of 4 domestic violence. He's got 4 previous wives, beat them all, convicted of beating them all. So now he's on his 5th wife. He's in the interrogation room. The detective says, well, isn't it true that you beat your first 4 wives? Well, the state can't, regardless of his answer is yes or no, the state can't bring that in. Look, in his own statement, he said he denied beating his first 4. Well, that's not true. defendant did not, the state's brief is wrong when they say the defendant put it in the issue.
About 1 minute.
Because
by the way.
the defendant didn't take the stand. The defendant's credibility was not an issue. So when you get an irrelevant question, do you look at pornography on your phone? That doesn't make it admissible just because it was asked in the course of interrogation. It's a fair question in the interrogation, but it's inadmissible evidence at trial. So the defendant did not put that in the issue by denying that he watches porn on his phone. Thank you.
Good morning, Mark Koza on behalf of the state of Ohio and Lorain County Prosecutor Judy Townsend. May it please the court. Looking at assignment of error 1, we've gone through this with appellant's arguments here about whether or not it was an abuse of discretion for the trial court to let in. Obviously that standard is whether or not the trial court's was unreasonable, arbitrary, or unconscionable. And we're dealing with 2 exhibits here, specifically State's Exhibit F, which is 62 pages of internet browser history, State's Exhibit L, the one video of a blonde girl performing oral sex on a man. Looking at these exhibits, specifically we have count 3 as brought up earlier, dissemination of matter harmful to juveniles. So CR testified, and when she was interviewed by the police, she said that she was shown a video on her phone. She testified initially that she was shown a video on her phone, and it was a man with a erect penis. On cross-examination, it came out that the female was blonde-haired and wearing a green shirt. So initially, prior to this exhibit getting in, the state tried to get in all the videos that were on the phone because a cell bright extraction took place. The trial court said no. There wasn't enough testimony of that from the CR. We're not going to let that in. Then trial counsel of the state said, well, judge, there is one video we believe matches her description. Can we have an opportunity? Which then they did produce. The judge said, I'll preliminary let it in. And then Detective Kasparovich testified. Looking at that issue of showing the pornography to the phone, as we said, that exhibit goes directly to count 3. It goes towards her credibility, CR as her testifying, and it goes to Perry, who, when CR was interviewed by the police, she said, he showed me a video on the phone. She testified to that. And then he was interviewed by the police. He willingly gave an interview, and he denied looking at pornography on his phone on those days. Well, this evidence goes to directly contradict him. I understand defense counsel is saying, well, his credibility is not an issue. Well, it is if he makes certain statements denying it to the police, which can come in. It's a hearsay exception, and now we have to disprove that. As I said earlier, the court initially said, no, we're not letting in State Exhibit L, but then it was pared down to evidence that corroborated the testimony. And that is correct that the victim, CR, didn't say to the trial court, yes, this video being played right now is the one he showed me. That was not what took place. So I would say that there was nothing unreasonable, arbitrary, or unconscionable by the trial court in letting in these exhibits. Looking to whether Rape Shield was implicated, I don't believe these are other acts, as I stated, that they went towards the credibility of CR's testimony, they go towards the elements of count 3, and they go towards even Mr. Perry, who put into issue that he didn't look at pornography on those days, but the downloading of his phone shows that he did.
Was there any limiting instruction given by the jury regarding this is used for credibility purposes only, or anything about other acts?
No, that is correct. I don't also believe that the video was played. I believe that it was this exhibit which was shown saying where it was on State's Exhibit L. The detective said yes, this is a video, and then that was described, and that was it. So it wasn't a video. This wasn't dealt
Well, not necessarily played during court. It was submitted to the jury for their review if they chose to review.
Yes, correct, Your Honor. With regards to assignment of error 2, well, I would say that sum up that believe that Perry's argument on assignment of error 1 is without merit and should be overruled. Do not believe Rape rape shield is implicated. These were not introduced to show that he likes to masturbate or whatever he does with the pornography. As I said, it goes to corroborating CR's testimony, elements of count 3, and to the issue of what Perry said they didn't look at porn on those dates. With regards to assignment of error 2, ineffective assistance of counsel,
Was there any testimony or discussion about whether there's a way to, for the exhibit regarding the internet search, rather than describe these by title, but describe them as Pornhub or where they came from, that would generally say they were pornography, but not the more prejudicial terms that have been used by counsel today?
No, there was just an objection to the entirety of that. The state did ask those questions. What are the videos? Skinny, young and old, and then daddy bangs daughter when mom disappears. Those were directly asked, but there was nothing limiting those things. That is correct. With regards to the ineffective assistance of counsel, defense counsel bases the ineffective assistance, particularly on that Perry failed to contemporaneously object to the introduction, which would have been of State's Exhibit, State's Exhibit L, which was the pornography. He is correct that failing to object does not preserve it for review. That's why we have such things as plain error review. He then says that he bases it on State v. Mays, an 8th District case that says failing to object to unambiguous law, there's no justification on failing a client on an issue of unambiguous law. State v. Mays is just factually and legally distinguishable. I understand the principle he's trying to get at, but ultimately it's a case where a lawyer said, I believe is you're going to get 4 years in prison. That's our understanding. Based on what that person pled guilty to, that was not possible. So you can't advise your client on inaccurate law or inaccurate outcomes. Ultimately, so I don't believe that this issue that, as I stated in my brief, that failing to preserve an issue is not, as this court has held, has not been a basis to establish an effective assistance of counsel. If it was, I don't believe that that was an issue here, because ultimately, you're entitled to competent counsel, but you're not entitled to an error-proof trial. That's why we have such things as plain error.
As far as plain error, you're not, as I recall in your brief, asserting that they had to argue plain error on issue number 1, and they failed to argue plain error, therefore they must, in this case, lose.
No, I didn't make that argument, although could have, but we did not.
You did not. That's not something you rated in your brief.
We did not make that argument. And then ultimately, I would say that he then goes into a plain error review, which I can understand, which he's trying to get at, but once again, our assignment of errors, as this court has said, are roadmaps for the appellate court to review these issues, and trying to add in this other issue I don't believe is legally sound. Therefore, I believe there is no legal basis for Perry's second assignment of error, and thank you for your time.
Thank you.
We seem to agree on the ineffective assistance of counsel. I read the state's brief to say that the objections were sufficient enough for the judge to rule on. I threw in count 2 because it was 4 out of 5 objections, and I thought, well, if I'm missing something.
So if this court were to reach the merits of assignment of error number 1, you would say that there was not an ineffective argument claim on number 2. Is that fair?
Correct, yeah. And the failure to object was actually only Exhibit L. I should emphasize that too. With regard to the general laws to the abuse of discretion, the state properly cites case law, but maybe you have it. I saw it early in my career, and I've seen it lately, but I can't find it. Well, look, I'm not here saying the judge had it in for this defendant, was so angry at him she didn't want to give him a fair trial. But there is law out there that says when the judge makes a mistake of law, that is an abuse of discretion. In other words, the abuse of discretion that the state cites kind of goes more along the lines, well, is this an excited utterance or isn't it? What are the facts that support or don't support excited utterance? But technically, if the judge, in the end, makes an error of law, that is an abuse of discretion, and that doesn't require judge, not trying to give the defendant a fair trial. I also note that a defense, or the state spent more time arguing to this court how L is very relevant. Exhibit L, the little video of the flag show, was very relevant, and less time saying that the Exhibit F, Danny Bain's daughter when mommy's away and skinny teenagers, he spends less time trying to argue that away as relevant because it's prejudicial, in my view. So even if the court were to say, look, L's clearly relevant, it was substantially similar for the judge to allow it, we still have to deal with with Exhibit F, the general, what kinds of searches does this guy make on his cell phone? And again, I guess I'm repeating myself, but I have to part company with the state. The defendant brought it in himself by denying he viewed porn to the detective. First of all, the detective's question was to the last two dates of the indictment, the 17th and 18th of October. The exhibit went to the whole indictment period, so it's overbroad in that sense. And again, when you're in the playground of something that's inadmissible, and the detective is asking a question that's, do you watch porn on your cell phone? Because he's trying to get to, well, could you have mistakenly seen it? So when you just ask a question, do you ever watch porn on your cell phone? Just because he asks that, the entire subject is prejudicial and irrelevant. So whether your answer is yes or no, it doesn't come in. That's it. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you by the court with release and will also be made on the Supreme Court website. The court thanks both of you for your presentation.